Hello, my name's John Russell, and in this briefing I'll discuss the commercial court judgment in a case called the Thorco Lineage, in which Ben Coffer and I appeared for the successful cargo interests. The judge was Nigel Tier, and the judgment was handed down on Friday the 13th of January 2023. It's an important case addressing how the limitation sum is to be calculated for the purposes of limitation under Article 4.5a of the Hague-Visby Rules. In particular, where there is both physical damage and economic damage to the cargo. If I explain the facts of the case, that will probably help you to understand the point of law that was an issue. The Thorco Lineage ran aground in French Polynesia while carrying a cargo of zinc calcine to Australia. Now obviously the vessel had to be salved, and the cargo interests eventually ended up paying salvors about $7 million. A small proportion of the cargo, only about 10%, suffered some wet damage as a result of the casualty and salvage operations. The cargo interests commenced arbitration proceedings against the contractual carriers, alleging breaches of Article 3.1 of the Hague-Visby Rules, that's on seaworthiness. The carriers denied liability, but also argued that they were entitled to limit their liability, if they were liable, pursuant to Article 4.5a of the Hague-Visby Rules. And they said they were entitled to limit liability by reference to the weight only of the wet damaged cargo, the limit being at 2 special drawing rights per kilo of, they said, the wet damaged cargo. Now, at first blush, it might seem surprising that the carriers would be entitled to limit by reference to the weight of only the wet damaged cargo, given that the whole cargo had been the subject of the salvors maritime lien, and the salvage liability arose in respect of the whole cargo. However, the carriers said their argument was supported by a decision of Mr. Justice Burton in 2008 in a case called the Limnos, which I'll explain in a moment. For cargo interests, we argued that the Limnos was both wrong and distinguishable, and both parties agreed that the question of law in relation to the limitation sum should be decided by the court pursuant to Section 45 of the Arbitration Act. Now, to understand the arguments in more detail, it's important to have in mind the relevant wording of Article 4.5a of the Hague-Visby Rules. The key words of the article for the purpose of this case say that unless the value of the goods is declared in advance, neither the carrier nor the ship shall in any event be liable for any loss or damage to or in connection with the goods in an amount exceeding 2 special drawing rights per kilogram of gross weight of the goods lost or damaged. And essentially the question for the court in both the Limnos and the Thorco Lineage was what is meant by A, any loss or damage to or in connection with the goods, and B, the goods lost or damaged. In the Limnos, Mr. Justice Burton held that the goods lost or damaged referred only to goods physically lost or damaged. It didn't include, he said, goods which were economically damaged. If there was no physical loss or damage, any claim for economic losses would be unlimited. But if any physical loss or damage was sustained, then economic losses would be limited by reference to the weight of the cargo physically damaged, even if the economic losses arose in respect of the whole cargo. Now that analysis has now been rejected wholesale by Sir Nigel Tier in the Thorco Lineage. His key reasoning in this case was that where goods are carried by sea, they may be damaged physically or economically. That's sort of stage 1 of the analysis. Step 2, Article 4.5a seeks to impose a limit on all claims for loss or damage to or in connection with the goods. So step 3, the textual context in which the words goods lost or damaged are used, it is one in which they serve to quantify the limit for all such claims. Next step, it would frustrate the purpose of the article if those words were confined only to physical damage. Therefore, next step, the phrase goods lost or damaged means goods lost or damaged physically or economically. And indeed, Sir Nigel held that that meaning is in any event the ordinary meaning of goods lost or damaged in the context of contracts for the carriage of goods by sea. Sir Nigel also held in the alternative that even if he were wrong that goods lost or damaged included economically damaged goods, in this case there was more than just economic damage to the whole of the goods because of the imposition of the salvors lien, which undoubtedly, he said, constituted damage for the purpose of the article. And because there could be no real doubt about the matter on this alternative ground, importantly, he refused permission to appeal to the Court of Appeal, as any appeal would have no realistic prospect of success. Now, that does mean that on one view, on the question of whether goods lost or damaged encompasses economically damaged goods, there are now two inconsistent first instance decisions. However, Sir Nigel's decision in the Thorco Lineage contains a very thorough analysis, whereas with respect, much of the Limnos decision consists of rather short conclusionary statements without much analytical underpinning, and it has been the subject of considerable criticism in the academic literature. And perhaps more importantly, Sir Nigel's decision avoids the anomalies, frankly bordering on the absurdities, that the Limnos decision could produce. And it means that economic loss claims, where there's no physical damage, are not unlimited, which always seemed anomalous. It therefore takes the law in a much more sensible direction. It remains to be seen how it will be addressed by the textbook writers in due course, but I would be surprised if the Thorco Lineage is not seen as now accurately representing the law, and the Limnos decision is treated as anomalous and wrong. Thank you.